All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 25th, 2025. We are on voting list number 17, and we're going to start off with Senate Bill 858, which needs to be re-referred to which committee? Is it?
Finance.
To Finance. All right, a motion to re-refer Senate Bill 858 to Senate Finance Committee. Is there seconded? All right. Senator Henson, yes. All right, Senate Bill 858 has been re-referred to Senate Finance. We're now going to go on to House Bill 844.
House Bill 844 increases the salaries of certain public officials in Somerset County. This is a cross-file of Senate Bill 717, which was passed by the Senate already. Seventeen.
All right, there's been a motion for favorable. It's been properly seconded. Is everyone okay being recorded in the affirmative? Or is there further discussion? All right, House Bill 844 passes unanimously. We'll now move on. Senator Walsh right here. Let's go to House Bill. Jamie, ready for 442?
442, yeah.
House Bill 442. 442.
House Bill 442 generally expands statutory evidentiary provisions that authorize the admission of an out-of-court statement in a juvenile court or criminal court proceeding made by a child victim or witness to certain professionals under specified circumstances to also be applicable to statements that are made to a forensic interviewer. The bill defines a forensic interviewer as a professional who, one, is trained in child forensic interviewing protocols and techniques that allow for neutral, legally sound, non-leading, and developmentally appropriate interviews with children to gather information without inducing the information provided by the child. Two, is not a law enforcement officer, and three, is employed by or works under contract with a child advocacy center or an entity in another jurisdiction that would qualify as a child advocacy center in the state. There are no amendments.
I move favorable. I don't think there was no opposition to this, as I recall. Let me check. The Episcopal Diocese didn't like it. The Episcopal Diocese said no.
So there's been a motion for favorable. It's been seconded. Is there any further discussion? All right. Is everyone okay being recorded in the affirmative? Okay. House Bill 444 passes unanimously.
442.
442. That's what I just said.
Pass mine too?
What's next?
Yep, you're next. Yeah, and then so Senate Bill 333, which is the identical cross file. There's a motion for a favorable.
Second.
It's been seconded. Is everyone okay with being recorded in the affirmative on Senate Bill 333? Oh, sure. Hold on a second. All right.
On the Senate.
Yeah. Yeah. Senator Folden wants to be added on. Is everybody okay with that amendment?
Fine.
Or sponsor amendment? All right. Now the bill is before you as amended. Motions for a favorable with the amendment. Seconded. Everyone's okay being recorded. Senate Bill 333 with the amendment passes unanimously. All right, we're now going to go back on to House Bill 182.
House Bill 182 repeals a statutory provision that sets a maximum amount of $40 for civil penalties imposed on the driver or owner of a motor vehicle that exceeds a posted speed limit and is recorded doing so by a speed monitoring system. So instead, the bill establishes a escalating penalty structure. Specifically, the penalties would be if you're exceeding the speed limit by 12 to 15 miles per hour, $50, by 16 to 19 miles per hour, $70, by 20 to 29 miles per hour, $120, by 30 to 39 miles per hour, $230, and by 40 miles an hour or more, $425.
So we have the Beltway speed camera bill, which is in the midst of being worked on. If this bill passes, and that bill specifically says $40 for violation with that regard to the speed of the car above the posted speed. If this bill passes, would this affect that and vary the fine depending on how fast the car is going?
So it would not, because that is drafted to a new, different section, and this one applies to the existing section, which is 21809, so it would not apply to that new section.
That's fine, because on the floor, several times I used $40. I would not want to have been incorrect in my statement. Thanks.
And we're looking at HB 182, correct? Are we intending to amend this with the amendments that were talked about on Senate Bill 118?
Yes. I didn't realize, the short answer is yes, if that's okay. Yeah. Is that okay? Yeah, the short answer is yes. I didn't realize that, that we had not drafted it to the House bill. And so if we could, why don't we hold this? And that will require it to go back to the House. If you guys are open to it, I know we're doing this on the fly, it would be my preference that the lowest level of speed, if we're already sending this back to the House to reflect Senator Sidnor's amendment, it would be my preference that the lowest level be returned to the original $40, which is the current fee. I think it's important that we're trying to show our constituents that this is not for revenue. And the fact that the House raised the lowest level of fee from 40 to 50, to me, the juice doesn't seem worth the squeeze. And so while we await the Sidnor amendment, if it would be okay with you guys, I think my preference would be to keep it at $40.
You know, the school zone, the distance. Oh, yeah.
That's a good. That's right. We were calling.
And then to hold the Senate bill as well, of course.
All right, so then we're going to hold both so we can conform to what we did in the Senate. We'll draft up the school zone amendment and then the consistent with $40. All right. All right, now we're going to go into bills 370, House Bill 375.
House Bill 375 is a cross-file for Senate Bill 392, which is still in the committee's possession. The bill authorizes a person to ride a bicycle, play vehicle, or unicycle on a sidewalk or sidewalk area unless prohibited by local ordinance. Under the current law, a person may ride those vehicles on a sidewalk only where it's proactively allowed by local law. The House did make one change, which is just simply add the phrase Jay's Law to the short title of the bill.
All right, Senator Love, and there's a motion on the table, but let's Senator Love first.
So I would just like to explain why they titled it Jay's Law. If anyone is curious, this is after Delegate Jay Jacobs, because when he was 5, the mayor of Rock Hall took his bicycle because he was riding on the sidewalk, and he still remembers this to this day. So this is for Jay Jacobs.
The way I understand this is flipping the opt-in and opt-out, correct? Yeah, so coming from a community that has a lot of senior citizens, I don't understand why we need to do this, and I'll be voting no against it.
Excellent. So there's been a motion for favorable. It's been seconded. Is there any further discussion? Okay, let's do a roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Buse.
Yes.
Senator Folden,
For J, yes.
Senator James,
Yes.
Senator Henson,
Yes.
Senator Love,
Yes.
Senator McKay,
For all of my constituents that growing up in the city of Cumberland have always known that you're not supposed to be riding your bicycle on a sidewalk, where we are going to pass a law that is, to be perfectly honest, just make it easier for them to do it, I'm in hell no. Thank you.
Senator Charles,
Yes.
Chairman Smith,
Yes.
10-1.
Passes 10-1. The Senate, 392 is the direct cross-file, is that right? Do you want to add the title?
Sure, let's put them in the same posture.
Okay, so we're now dealing with Senate Bill 392, which is the cross-file of House Bill 375. There's a motion, there's an amendment that would like to be added on to retitle the title of the bill, Jay's Law, JJ's Law. Is everyone okay with that amendment? Or it's been seconded, everyone's okay with adopting it? Now the bill's before you as amended. Want to be recorded in the same vote as you passed House Bill 375? All right. Senate Bill 392 with the amendment passes 10-1. Is the House still on the floor?
Yes.
House Bill 674.
House Bill 674 is the cross-file to Senate Bill 394. As amended by the House, the bill provides that a person may not, with the intent to conceal a crime, knowingly and willfully dismember, destroy, remove, bury, dispose of, or obliterate by any means any portion of human remains. Also prohibits a person from aiding or abetting another in violating this prohibition. Violators are guilty of a felony and on conviction subject to imprisonment not exceeding 5 years. Moreover, sentence imposed under the act may be consecutive to or concurrent with any other sentence imposed for any other crime based on the act establishing a violation. So I think, for example, like evidence tampering, which would, I believe, be a 3-year misdemeanor, that could either run concurrent or consecutive.
From biking on the sidewalk to dismemberment. All right. Senator Sidnor.
Recall when we were having the discussion about Senate Bill 394, we were trying to deal with the phrase intent to conceal the death, and we were struggling with that. This one, it goes beyond, it seems to be much broader because it says the intent to conceal a crime. So it's not necessarily about a crime against a person anymore. Would that be your interpretation, that this is a much broader bill now?
I think that the element would then be that it's concealment of any crime. Wouldn't necessarily need to be a homicide if that's what you're asking.
That's exactly what I'm asking.
Right.
What do you think?
I understand how it's fair to portray that part as broader, but I actually think of the bill in its current posture as narrower, because people will sometimes, as the testimony in the previous bill indicated, conceal a death that is not a crime. In other words, if there is a stillbirth and they, for some reason, want to conceal that, they can do so. That is not a crime. The previous bill made that a crime. So I think this bill is narrower, and appropriately so, because it only involves the concealment of a criminal act. not something that we may find distasteful but is otherwise not a criminal act. That's why we didn't move the Senate bill. I think the House came up with a more appropriate solution that deals with that concern.
I know in the group that we had, the idea was initially to delete the word "the death" just for that purpose, and we were looking at the term homicide. But again, this goes beyond homicide. This is a crime. I probably would feel more comfortable with using the word homicide rather than a crime, but I'm just seeing this and trying to digest what this exactly does versus it just being homicide.
There would probably need to be some nexus between the crime being concealed in the body, because you're really not going to have a violation unless you have both the intent to conceal a crime, and that's the motivating factor for concealment of the, dismember, destroy, remove, burying, dispose, et cetera, of human remains. So I think just by implication, there's sort of a nexus that needs to be there. I'm trying to imagine a crime that somebody would, I don't know, I'm really struggling to go outside of the box here. Yeah.
I don't have a problem, I think, getting at what we were talking about, getting at with Senator Bailey's bill, but I agree. I think we still need to figure out how to phrase this. So I don't mind working on it. I would ask that we just hold it.
Senators asked for a hold. We'll honor that. It's still early enough to continue to work. Let's go ahead. If folks still have questions, want to make sure. Okay. All right, we'll hold. So then House Bill 674 and 394 have been held to the next voting session, which is tomorrow. We'll now move on to House Bill 7.
House Bill 7 is the cross-file to Senate Bill 627, which is still in the committee's possession. The bill authorizes a person operating a bicycle when approaching a stop sign at an intersection with a highway with 2 or fewer lanes to cautiously make a turn or proceed through the intersection without stopping. If the person reduces their speed to a reasonable rate and yields the right-of-way to any vehicle in the intersection or approaching the intersection that is near enough to pose an immediate danger. The House passed the bill without amendments.
Thank you, Mr. Chair. And I know this is the cross-file of your bill, so if you would prefer me to wait if you want to introduce it. Okay, thank you. Colleagues, I spent a lot of time on this bill over the last couple of years. And as Council mentioned, this has bicycles treat stop signs as yield signs, as drivers do with a yield sign. It doesn't mean they can just blow through a stop sign. And I know it seems counterintuitive just thinking about it, but the data and the experience that cyclists have actually prove that this is a lot safer. In Idaho, this is known as an Idaho stop because Idaho was the first state to come up with this. They saw a 14.5% decrease in the injury of bicyclists. In Delaware, they did a test. The 30 months before the law and 30 months after the law, they saw a 23% drop in crashes involving bicycles at stop signs. The National Highway Transportation Safety Agency published a 65-page research and analysis report of the other states that have this law. It is incredibly comprehensive, and their data is clear that this is safer. So you may remember at the hearing, one of the chiefs came up and testified that they opposed to this bill. And I asked him, have you read the NHTSA study? And he said no. I followed up with him afterwards. He had read the NHTSA study. He'd talked to an engineer and a cyclist, and he confirmed, that these things show that it is safer. And I said, so what is the chief's and sheriff's position right now? He said, well, we acknowledge that NHTSA is the subject matter expert in all matters transportation. So the other thing I want to put out in terms of law enforcement is in all of the other states where the law enforcement weighed in, they unanimously supported this bill. And at the beginning, where there were states where law enforcement was split or they weren't sure, after the law went into effect, they unanimously support it because it is safer. And then just to close, I know I'm throwing a lot at you, but just to close, of the states that have these have been proposed by members of both parties. They have been passed in a bipartisan manner. This is not a political issue. And I really hope that we will move this. And I see there are comments, but when it's appropriate, Mr. Chair, I'd like to move the bill.
Thank you, Mr. Chair. So I guess my question is, here we are again, we're trying to legislate, like, I don't see police officers stopping people on bicycles for rolling through a stop sign. I don't see them stopping them for rolling through the red lights in Baltimore City. I don't see them doing, it changes nothing on the liability. It changes nothing as far as enforcement strategies because they're just not doing it. I mean, so I just don't know what we're doing here. We're trying to legislate something that I see as, and your statistics, I appreciate you bringing those. They still change nothing as far as the subjectivity of some of the language in here, which is talking about, they reduce the bicycle to a reasonable rate. That's subjective. Any approaching vehicle on another highway that is near enough to the intersection that it poses an immediate danger. Subjective. These are all, it changes nothing as far as who's at fault, whether they stop or they roll through. So I just don't understand why we need this. And so I just, with the subjectivity, I think it makes it more, it muddies it more than it gives clarity. Thank you.
Thank you. I appreciate that, Senator, and it does change a lot, actually, because with the education that will come along with this, and I've already talked to MDOT, they're supportive, and they will go out with a big education program. MVA will educate folks, and that way everybody will understand what is going on, and that is what is going to reduce the crashes. When drivers and cyclists understand that this is what's going to happen, that will reduce crashes. And I go back to, the data shows it's actually safer because people understand what's happening.
Once again, I think this is a senior citizen issue. I don't care what the data shows. Any of the testimony is all about the bicyclists and the safety of the bicyclists. It does not take into consideration the senior citizen driving. Bicyclists in general just do whatever they want to do, regardless if they get to do it or not to do it. And those people that are on the roads have to adapt to somebody making quick decisions, either to blow through or not blow through. I see it as a safety issue, and nothing has been presented that says senior citizens would support this.
I just had a few questions because I'm trying to go against what you're taught, which is a stop at it. So this is just a few questions. Again, you said that you talked about it making it safer, and the question, safer, and I think Senator McKay said safer for the bicyclists. Is that who we were talking about when we were saying it makes it safer?
I think it's safer for everyone because it reduces the crashes.
And who's crashing into who?
Cars and cyclists.
Is a cyclist coming into the car? Is the car hitting the cyclist?
The cars are hitting the cyclists.
Because they're not stopping?
So
that's what I'm trying to understand.
So I think it's a number of things. One, when a cyclist stops at a stop sign and then they begin to go, they don't have the momentum, so they're much wobblier. And so it's harder for them to swerve if a car is coming. And along those lines, our eyes will catch something in motion more than it will catch something that is stationary. So a car is going to see a cyclist in motion more than they're going to see a cyclist that is stopped, and then they start going. So I think it's just safer all around, based on what NHTSA said.
And in these states that you were referring to that have these, who allow for this, do the stops, is it different signage that's attached to the stop sign? So that it's, I mean, because again, if I see a stop sign and I see somebody run through it, you broke the law in my eyes.
That's where the education comes in. I'm not aware of any sign on the stop sign that talks about cyclists, but that's where the public education campaign would come in, that MDOT has already said they're ready to do.
And these are not motorized bicycles. These are actually pedaling bicycles that, or is it, what kind of bicycles are we?
Counsel?
Just pull up the definition.
And I ask because if they're motorized, I mean, then I guess the argument will fall away that about getting the momentum back up. I'm guessing.
Well, even if they stop, the motorized help, you've got to pedal to get started.
Yeah, so the definition does include electric bicycles.
Which, and again, I'm asking because I don't know. I don't have one of these bicycles. I'm assuming it gets this rate up pretty quickly, right? It can be back up to speed and.
It can. It depends on how you use it, but motorized bicycles still can't go above 25. But once you get started, then the motor can kick in.
Thank you.
Actually, there's a throttle on it.
Thank you.
The advocate you work with, Senator Smith, came to see me. He did an excellent job of softening me up on this bill, and I'm inclined to vote for it. But actually, Senator Senor's question was really so excellent, and I don't want to press you, Senator Love, if you don't know, but I think it would be extremely important to me to find in the report that the nature of the accidents is, in fact, the full, the result of full stop, and I'm a bicyclist, and then getting back that momentum. If that is the main reason, then I think that bill helps solve that problem. If there are other reasons these crashes happen that are not because of that momentum, then I'm sort of thinking that Senator Folden's onto something about this is not solving a problem in the way that it should. So do you remember what page it's on that describes the nature of the accidents? Because I don't, and I didn't read it with that much, level of detail.
I don't think it went into all of the different permutations. What I do recall is the very, apples to apples, 30 months before the law, 30 months after the law. And there was, what was it in Delaware? 23% drop in crashes involving bicycles at stop signs. So that, to me, is incredibly powerful. You are comparing apples to apples.
I don't know, because correlation and causation are two entirely different things, and so that's why statistics, because I study statistics, it is the devil of a thing to look at and are easily manipulated. Not trying to press you, but I think it's so important. If I can grab that report, I'd like to hold this bill, actually, because I'd like to, study it real quick and see if there's any detail, because everybody seems to be assuming that the accidents are happening primarily because of the momentum issue that's so different from a car's powering versus a bicycle powering. But if these accidents for other reasons, which I won't get into now if I see that, then I think we might be exacerbating the problems. So if I could borrow the report, I'd really appreciate it. Thank you, Mr. Chairman.
Absolutely, and I don't mean to say that was the only reason for the crashes.
I don't know if we know. That's why I'm going to look at that. I'm going to come over and get it from you. Thanks.
Excellent. All right, so Senator James asked for a hold, so she could review the report. Yeah, so we're going to honor that request. We've still got enough time. We're going to vote tomorrow, but Senator West, go ahead, and then we'll move on.
Okay, let me just express my concern. So here's a hypothetical. You've got two 11-year-olds on bikes. They come to an intersection with a stop sign. One of them stops, the other one sails right through. And then when the one who stopped gets going again, he says to his friend, "You just went right through that stop sign." And the friend says, "We don't have to stop at stop signs. We can go right through the intersections." It will be expressed without nuance, and nothing will be expressed about how you have to reduce the speed to a reasonable rate. And I'm concerned that the 11-year-old now will get the message that he doesn't have to stop for stop signs and can go right through the intersection. And the 11-year-old in the future will go through an intersection and get hit by a car. Or here's another possibility. The 11-year-old comes to the intersection and says, "Gee, either I could slow down, maybe stop and let the car go. If I speed up a little bit, I can get past it before the car gets here." And the 11-year-old misjudges the situation and goes through and gets hit by the car. That's my concern is not so much about the adults, it's about the kids.
Thank you, Senator. And again, it all goes back to the education. So when these kids are learning to ride bikes, they should be taught about what yield means. And they're taught about yield signs, so they know what that means. And so they should be taught what a stop sign means for a yield sign for a cyclist. It's the same thing for 16-year-olds who are learning how to drive. They're taught what a yield sign means, and they're taught what they're supposed to do. And so the point of this is as incongruous as it may sound, is that it is actually statistically safer. So that's what we're trying to get at.
Kids don't do well with nuance. So when you teach your kid that the cars have to stop at the stop signs, but you don't, so long as this and so long as that and so long as that, I can see kids, the lesson that they get is we don't have to stop at the stop sign. We can just keep right on going through, and that's going to lead to tragedies.
Senator, you could say that just about anything. And so that's where we as parents and, those people who teach kids how to ride bikes, that's our job, is to teach them.
All right, so we'll hold it till the next voting session. Have some members have opportunity to review the NHTSA. Sure. Oh, sorry. Yeah, I'm sorry. His light was not on. My apologies. Senator McKay.
And that assumption wasn't on my physique. But that being the case, most electric bikes do have a throttle that you can actually, in the sitting position, be able to take off. The pedal assist doesn't necessarily have to kick in. Once it does kick in, the throttle is disengaged and it goes with the pedal assist. So you can, at a stop, take off very fast.
All right, so we're going to hold that till the next voting session. All right, we'll now move on to House Bill 413.
House Bill 413 is the cross-file to Senate Bill 925. The bill establishes reduced penalties for cannabis-related violations of the prohibitions on being a volume dealer under Section 5612 of the criminal law article, and a drug kingpin under Section 5613 of the criminal law article. The bill authorizes specified individuals who are incarcerated for violations of the drug kingpin and volume dealer statutes to file an application for a modification of reduction of mandatory minimum sentence. The bill modifies penalties and crime classifications for specified firearms offenses and authorizes a person at least age 21 to manufacture a personal use amount of cannabis products or concentrated cannabis as specified in the bill. The bill also provides in statute that with the exception of a violation involving cannabis, the violation of the volume dealer statute is a felony.
All right, questions from the committee? So, yeah, it's House Bill 413. Yep, 413. Yeah. Senator Henson has a question.
Thank you, Mr. Chair. Council, could you unpack for me the changes to firearm offenses?
So it's on page 8. Go ahead, sorry, go ahead. She asked for councils. Go ahead.
Sure. Beginning on page 8 at line 11, 5138 of the public safety article, that's the prohibition on disposition of a stolen regulated firearm. This would make that a felony. Currently, that prohibition is, the penalty is provided under a general penalty statute in that subtitle that provides that it's a 5-year misdemeanor. So this retains the penalty but increases the, or modifies it to a felony instead of a misdemeanor.
One caveat there, though, if the firearm is worth, let's say, $1,500 or more, it would be a felony under the current law. I know it's a different statute because it's theft statute, but I'm saying it would be a felony based on the price of the firearm.
Sure.
May I? So I know a lot of thoughtful work went into if a stolen firearm should be a felony offense or if it should remain a misdemeanor, and it just should be classified based on the value of the firearm. And then there was some discussion about linking the two things. If we're going to increase the penalties for a stolen firearm, also looking at the penalties for failure to safe store your firearm, penalties for not reporting your firearm stolen, kind of those other things that are other features of that firearm being stolen. Is there any work in the bill specifically about that? Do we have any other bills pending that would tackle those other areas?
We had, so I was had the bill for safe storage, I think 2 years ago at this point, and we teetered on this with increasing the penalties, and if someone were to get killed or injured, increasing those penalties under those circumstances. We did end up increasing the penalties slightly on that, for safe storage 2 years ago, but we didn't go, the reason we didn't go farther was because if someone were to have been killed, let's say it's in your house, a lot of the testimony and a lot of the dialogue at that point was well, now someone who failed to safely store their firearm lost a child or a loved one, and now you're going to send them to jail for 10, 15 years. So we kind of had that conversation, and that's where we landed. But that's not in this. It was not in this bill, but it has been the subject of conversation for the last couple of years. And I do think we had a bill this year that dealt with. Did we have a bill this year that dealt with safe storage?
Yeah.
Maybe Senator Hester had one.
Okay. Did we pass it?
We did not.
Okay.
Same dialogue loop as 2 years ago.
Yeah, I struggle with that. What was the rationale on including it with the kingpin statutes?
That's a strategy question.
Okay.
So from the other side, so look, in walking through the bill, I mean, I know, and I think council, look, we get rid of some significant mandatory minimums here, and that's in line with the work that we started with JRA. And so if you go on page 5, you're looking for, and really we're knocking this down, it's on lines 13 through 15. So you're looking at this for, you're cutting that down from a 5-year mandatory. It's still a felony, but actually you're taking it to a misdemeanor, and you're taking it from a 5-year mandatory and $100,000 maximum fine to a sentence not exceeding 10 years and not exceeding $50,000. So you're getting rid of some of these, I think, antiquated mandatory minimums for this. And then if you drop down, this is again for the volume dealer piece. That date of September 30th, 2017 is the date that, and I think only one member in this committee was on there. I think you were on JRA, were you not, Senator West? 17. JRA? 2016. 2016, 27, is when so 2016, because that was 2016, is the law went into effect on the 17th, yeah. You were an HTO then, right? Yeah. And so this moves this in line with some of the work that was done with JRA. That's why that date is there. All right.
It
Just
doesn't
keep going, yeah.
pose any issues on single subject rule to talk about the volume dealers and then just kind of throw in there the,
So without a specific analysis of this bill, I am aware that there has been at least one case in the past that asked the question about guns and drugs being in the same bill and whether there was a common thread or nexus between those two issues. And the result was, or the conclusion was, that there was a sufficient enough nexus between those two subjects to fit within a single subject.
specifically the theft of firearms? Like, I could understand if it was in the commission of a crime and we were talking about using firearms to maintain a drug enterprise, maybe, but this is about the theft statute.
Right. And that's why I sort of prefaced at the beginning with, without a specific analysis of this, if the, committee would feel more comfortable, that could be something that you could refer to the Attorney General's office for a determination on whether they think that single subject is violated with this.
I would feel more comfortable having a better understanding of that because I do think they are discrete issues and that there's been a great deal of advocacy and debate around whether we escalate it to a felony or not, and to kind of loop it into a bill that has some other really good benefits in terms of justice reform, but then this kind of goes the opposite direction of that. And then just seeing the nexus between a theft statute and kingpin law, I don't see the connection there. And if we had an opinion, I know I'd feel more comfortable voting on the bill. But that's just me.
So we'll ask, so I want to go to Senator James and Folden, or which one was first? I think Senator James was first, and then Folden. And
Thank
we'll
you.
come back to Senator Henson.
Mr. Chairman, I think I might be directing these questions to you. I support the bill generally, but I want to remind myself, with your help, of why we want to reduce the penalties for distributing 50 pounds or more of cannabis. And let me make a caveat. I realize we have legalized it, and so, it's a legal substance under certain circumstances. But what's troubling me is the state's attorneys are reminding us that there is still a lot of violent crime around, I guess, the illegal production of cannabis. And so I'm struggling with why that's happening. I get black markets for sure, but violence and cannabis. So I'm struggling with that part of it. So can you remind me, or just let me know your thoughts about those two issues that were, obviously it's legalized and we're trying to reflect that in the way we, determine the penalties for this. But still, for some reason, there's a lot of violence around cannabis. And it's clear if you're over 50 pounds, you're not really doing personal consumption here. So what do you know about that?
No, I mean, I think that's part of the
balance?
strategy, again, the nexus with the firearms piece as well, with the conversation we kind of just finished.
Right.
But the real piece is just about just the fundamentally flawed, like, war on drugs. I mean, and that whole thrust of mandatory minimums and significant financial penalties. You still get significant penalties and the ability for significant fines under this bill, under this adjustment. It just gives for more flexibility for the judge to make those case-specific determinations without having to impose a mandatory minimum.
Now, I know and I think the war on drugs is an utter failure.
Yeah.
There are better ways to do it, and shame on all of us for not working harder on that issue. But in that sense, doesn't the bill leave untouched other mandatory minimums with other drug offenses? So if you really wanted to, correct for the war on drugs mandatory minimum, sort of punitive without rehabilitation, we're only doing that narrow lane of cannabis. Is that correct? For now, is that right?
Well, no. So the first part, I mean, look, the first part is with cannabis,
Right.
And then the second part is for volume dealers and kingpin.
But only cannabis, right?
No. So just to be in all candor.
I'm sorry, I didn't read it right.
No. So on page 5, lines 17 to 25, you see that.
Hold on, just give me a sec, because I was reading the fiscal note. Yeah. Right, sir. And I know we met, I'm sorry, tell me the page, no,
17, right there.
So,
what page? Oh,
page 5. Yeah.
okay, I'll get right there, thank you.
So that-
I'm there, I'm
Let's
with
go,
you.
let's start on line 20, which is, like,
Thanks.
that's where that September 30th, that's the
Right.
effective date of JRA. And what was unaddressed in JRA, which we had some compromises going back and forth, but for section, 5-612 and then 13,
Right.
that's crack cocaine, okay?
Oh,
And so
okay.
that-
Yes, yes.
And that is, and then you see that 448 grams. That's a weird number, but 448, but it's about a pound, right? So you're looking, that was the discussion, and I didn't sit on the JRA panel, but I remember this discussion. I remember the deals that were cut on this. This, again, allows for, the option for a sentence modification, and then it drops down some of those fines.
Oh, I'm good with that.
Yeah,
I'm
yeah.
talking about, and that makes sense to me with the, because we demarcated crack
Yeah.
versus cocaine. No, I'm trying to figure out if prospectively in the bill for volume dealers, not somebody serving time, but
Yeah.
right now that we want to modify for for cannabis as well as crack, but for, drug kingpins outside of those two contexts, did we make any other adjustments? I mean, because right now I think the fentanyl heroin situation is so bad, not that penalizing people is going to stop the problem, but there's a lot of moral outrage, and rightfully so. So we didn't do any of that. We didn't change anything on other drugs at this point. So it's cocaine, which in the crack form, or cannabis. Is that?
That's right. So I said,
Okay.
yes, exactly right. No other drugs
So
were implicated.
what did you, when you're reading of this and trying to get yourself prepared to introduce this bill, what did you learn about this violence around, it's, in other words, I feel like we all are like, if you're a nonviolent drug offender, you need help more than you need punishment. But if it's circling around criminals and violence, how are we going to deal with that? Or how do you think the bill will still hold people in that arena accountable, fully accountable? Because the violence is the really awful part of it, right?
That's exactly right. So, I mean, what the bill does in these two incidents is it restructures the sentencing structure, okay, and then it provides for a pathway for resentencing for people that were who were convicted prior to the effectiveness of the state.
I'm okay with
So
that. I'm really worried about,
in both instances, there is a hearing, obviously, and that's, a judge has discretion to look at all of the facts of the case, and I think that discretion is what allows someone to evaluate whether there was violence associated, and actually there are factors that are listed.
oh,
but they're,
good. Where's that, sir?
Let me look at it.
Is that existing? It's new law, right?
Yeah.
Let's see.
Yeah, it's page 5,
Okay.
26 all the way down. And so those factors and judicial discretion allow for those conversations to be had
Yeah,
in each case to be
right.
evaluated on a case-specific
And
manner.
so your understanding is if, even with people serving time now, if it wasn't just, 50 pounds or more, but also around other charges of violence or, criminal activity and things like that, that the court could still look at. And is it your understanding that in lowering the penalties now for that 50 pounds or more of cannabis, talking about if somebody got, charged today, this would in no way undermine prosecutors showing that, if there was violence and conspiracy and, other activity, that the court would be able to properly impose penalties, punishment, and incarceration for the violence.
That's right. I
Okay.
think your characterization is correct.
All right, thank you.
Senator Fulton.
Thank you, Mr. Chair. So hold on, but we're asking for a hold so that,
He just wants to go.
no, I'm saying, but we're asking for a hold pending a AG opinion on the single subject? Okay, because I just want to be clear that the part of this that's, I guess, that other than the nexus between the drugs, 50 pounds seems a little bit more of marijuana than probably personal use. But the nexus between drugs and handguns especially is well documented. And what we're trying to do is, and most of those are not legally possessed when they're seized by law enforcement. I would say overwhelmingly, probably 99% of them are not legally possessed because there is a very strict prohibition for drugs being used to have your handgun license permit. So I think that I hear we want to get an AG opinion, but I would like to see us get this in a timely fashion, because the important part of this is that we're trying to show that it's not just about the monetary value of replacing a handgun that is stolen from a residence, but the danger and threat that it brings to our communities. That's how we should be gauging this.
And you just made a great point about violence.
I mean, the nexus of this with the violence, and what I was saying is that we can't just continue on these handgun issues where we're have people being murdered on our streets and say, well, he stole that. You know, that was recovered and it was only worth a $500, $600 handgun. So that's not a felony. It's a misdemeanor. It's the threat that the device or that the handgun presents to society in the hands of someone that is not legally or lawfully allowed to possess it. So I would just encourage everyone here to understand that's the idea behind this, that we need to make sure that we're handling this for all of our communities in the right light.
No, great. So we're gonna, I just fired up an email to see if we get that email response quickly so we can get back to this. But I do want to respect the senator's request. Tomorrow is going to be a different story because we're running out of time, so we got to keep pushing this stuff. All right. We're now going to go to House Bill 348.
House Bill 348 is the cross-file to Senate Bill 520, which is still in the committee's possession. It authorizes the State Highway Administration to place and use speed monitoring systems on segments of highways identified by the administration as safety corridors. There is one or several just minor technical fixes I think the bill needs. In the provisions of the code which are being added to here, administration is actually a defined term which refers to the motor vehicle administration. So there are a few places in the bill where it uses the term administration to refer to the State Highway Administration, but those just need to be corrected to say State Highway Administration. So just specifically on page 7, that's in lines 15, 19, and 26. Administration there should read State Highway Administration.
All right, I'd like to, all right, so for those clarifying amendments, we're going to, you don't have anything before you, we're just going to do it in concept. Is everyone okay adopting? Okay, okay, great. All right, now the bill is before you as amended. All right, further discussion? Hold on. Yeah. Someone have a question?
These are the same bills.
What's the difference in safety? What, is there a definition provided of safety corridor? Does this give the State Highway Administration carte blanche to put these speed cameras wherever they want around the state just by designating a stretch of road a safety corridor?
Yeah, so there is a particular report that the administration is required to file with the federal government, which identifies safety corridors, and there is a definition in federal law. I know I had it here somewhere. Let me see if I can pull it up.
So actually, I see it on page, now I'm finding it on page 7 of the bill as the definition of safety corridor. But that raises a larger question, which I think we should deal with, and that is, we've been passing all these safety speed camera bills on a one-off basis. We want this little stretch of road and this little stretch of road and that little stretch of road. We're taking an awful lot of time doing it. So what this bill basically says is, State Highway Administration, you make these decisions. Once you designate a stretch of road, wherever in the state it is, as a safety corridor, you get to decide to put speed cameras on that stretch of road. It basically takes it out of our hands. And it may be we want it taken out of our hands. It seems to me we're spending an awful lot of time on speed camera bills this year. But it does raise the issue as to whether or not we want to continue to control the decisions or just lateral the decision-making over to the State Highway Administration for state roads.
And I'm assuming, going back to that definition on page 7, lines 14 and 15, when it talks about a state highway, are we talking about highways? Or are we talking about roads? Is it all roads?
I mean,
Well, it's all roads that are under the jurisdiction of the State Highway Administration, essentially.
Okay,
And
thank you.
within that, only those that it has designated as safety corridors, which I don't remember the exact percentage, but it's in single digits, the percentage of their roads that they've designated as safety corridors.
Thank you.
Thank you. I think that I would like a bit more information about the bill, because Senator West brings up a good point about, but it's a big policy question about whether or not we delegate this authority, thinking about Congress is delegating everything, to, you know, an unelected group that we claim has expertise in this area. And I just don't know if they do, and I don't know what their policy would be. But if I could ask our staff, in federal law, is safety corridor used the way we're about to, which is a place on which speed cameras should be placed? Is that why the federal government has that phrase in the first place? That's one question. Then what other jurisdictions have, you know, borrowed that safety corridor phrase from the federal government and used it to allow for a statewide imposition of speed cameras to be determined by administrative bodies and not the legislature?
I don't know about other states. Yeah, since on the federal definition, it's essentially an area of high risk to vulnerable road users in a vulnerable road user safety assessment, which is something that the SHA is required to prepare to comply with federal law.
I'm guessing that what this is about is trying to help vulnerable road users. It's not a definition adopted by the federal government for use in imposing speed cameras. That's not where this language is coming from at all. Is that correct?
Not specifically, no.
Right. And then just as an aside, what is okay, here it is, a vulnerable road user.
Page 8.
Okay, right. So what we're worried about is areas in which, like, you have a deep curving road, if you will, and so bicyclists, pedestrians, and the like might be struck by cars. Yeah, I'm looking at that. Yeah. So that makes some sense to me, and probably deals with how to improve the safety on those roads. But that this term and the idea behind it have never been used to, create a statewide program by a bureaucratic agency to, put speed cameras where they feel like it.
Not that I'm aware of, no.
All right, thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chair. So I just, for this bill in particular, so this is my bill, but I'm not sure if with all of these different bills, I know I have a delegation bill for Route 5. I know we have Senator Muse's bill for 210, and then this bill in particular. Do we know the impact? Are we saying one thing in this bill in comparison to the others that'll contradict themselves over time?
So, I mean, it wouldn't be a contradiction, but this, like the bill we discussed earlier, this is creating a new section, and the penalty for this would be $40. So it would be, I mean, it wouldn't be contradictory, but it would not be the same as the penalties which would be provided for in those other bills.
Because I believe the penalties are a lot higher on 210. We've increased the penalties in that bill on 210, correct?
Not in current law, but
that's in the bill.
Yeah, the bill we have before us would do
So
that, yes.
how would the,
So this would
end
be,
up contradicting itself?
this would be $40 for the cameras that are operated under this authorization.
So he'll have cameras that are authorized under his bill, and this will have cameras authorized, so it'll be two different sets of cameras?
Correct.
That sounds a lot more complicated. I feel like we should probably get State Highway together and kind of look at all three of these bills or all of them and have a deeper discussion. It sounds like it's going to be a lot more convoluted than it should be. And this is my bill, so,
That's what I was looking at. I was like, yeah,
This is
man.
my bill, so.
I was looking at you. I was like, you're making some good points, but you're tanking your bill, bro.
Listen, I just want to make sure we're doing right by the people of Maryland, and we're not, going around in circles doing something crazy when we can just have everybody at the table for all of these particular roads. And I know 210 has been, when I was chair of the delegation, we were trying to get a lot of, get those bills out so we can increase the amount of cameras. And because there's so many people dying on that road, limiting it to $40 when his is trying to increase it up, it becomes a problem. But
All right, we got Senator Golden and Senator Buckman.
Thank you, Mr. Chair. I just wanted to ask the good senator, the sponsor, he didn't think about this before he dropped that thing?
Right.
Come on.
You gave you a solid 90.
Oh, I'm sorry. Was it out loud? My apologies, my friend. I apologize. I think that we could probably loop in Senator Love's stop sign bill under this also, because it would be included, right? They're a vulnerable road user. So it's all going to be absorbed. I really like where we're going here as a committee.
Me too.
And I just want to, and my good friend from Baltimore County brought up that we've had so many speed camera bills, but he's a main sponsor of a large one, old 695. So this is really a perplexing day for me. Wow. Well, at least I've remained constant on where I'm at on speed cameras. Is there a cap on the number of speed cameras statewide that can be put out in these safety corridors?
No, this is.
Okay, so and I think that they said that there was, I do believe it wasn't a single, like, below 10%, right? But if we don't have a cap, we have all these other safety corridors deemed by counties or other legislators that have their own special interest of where they want to put them. I just, look, we keep overextending. I mean, we're already taxing the heck out of our citizens. We're increasing fees, and this is just another fee on citizens. And does the language in this one come back in line with the same scheduling fee that Senator Sidnor brought up? Because would it be in these safety corridors, would it be then adjusted under that same? I was trying to look real quick, and I apologize. Does it have the fee structure broke down?
No, it's $40.
So it's just a flat $40 on this one. So we'll have this bill back next year to add in all the increased fines because we're going to need more money next year because we didn't get enough from our taxpayers this year.
You can't answer that.
Oh, I'm sorry. I apologize. But that's an important question. Like Senator Sidnor made a good point about when we brought in and we were doing the tiered on, I thought any safety speed camera thing to make it consistent across the state. Maybe I'm wrong. And now we have a bill that's already in conflict with that language. Am I wrong in that? Can I ask that?
So the bill we heard earlier, which it affects cameras which are authorized by section 21809 of the transportation article. This is adding a new section 21810, I believe, or 21811. So
218.
no, it would not.
Okay.
They would not be in concert with each other.
Okay, thank you.
Thank you, Mr. Chair. I actually had a question about the second part of the definition of safety corridor, but if I could second the Senate sponsors' comments, and I think it would be great to just take a step back and take a holistic view.
Those speed cameras, period, and I may have said this, I just have a hard time when I've buried people who were killed hit by a car. I have a problem when I look at them and say, gee, you know, we're causing our constituents to pay higher fees. Just slow the heck down and drive the speed limit, because we don't say that about shoplifting. They get a $100 fee. Selling marijuana, they get, and we say, oh yeah, let's increase that fine. Let's increase that fine. Only when it comes down to this do we do that. So having said that, it doesn't matter. That's only when it comes down to this do we say, gee, we're just increasing fees. How about they telling them to decrease their speed? And then, now it doesn't matter what y'all do with your speed camera bill. I'm not going back home to my JPR Committee and telling them that because we have so many speeding bills, I'm gonna get my bill, and I want the bill as is, and then y'all do in your neighborhoods what you want. Thank you.
Thank you, Mr. Chair. This would be brief. Earlier, I posed a rhetorical question about whether we should be comfortable just letting the State Highway Administration make these decisions. After hearing this conversation, I think that makes sense, but we need to circumscribe their decision-making with some parameters, which I don't think this bill does. In other words, can they charge $500 for speeding? The bill doesn't speak to that. Can they impose speeding fines on you for going 1 mile an hour over the speed limit? The bill doesn't speak to that either. So I'm going to endorse Senator Charles's idea that we should pull the bill back, study it more clearly, and then maybe give the State Highway Administration the power to do these things, but with defined parameters so we know the scope of what they can do under various circumstances.
Hold on to those two bills. We'll now go on to, so House Bill 349 and 485 are the same, right? They're the cross files of each other? Is that right?
Well, the House amended it.
Okay, let's hear the House Bill 349 and then we'll go to Senator Muse. Same the cross. What's the amendment?
So House Bill 349 is the cross-file of Senate Bill 485, which is still in the committee's possession. The bill, as we've been talking about, creates a graduated schedule of fines for violations recorded by speed cameras on Route 210. So as amended by the House, the schedule is for if you're going 12 to 15 miles an hour over the speed limit, $50, for 16 to 19 miles per hour, $70, 20 to 29 miles per hour, $120, 30 to 39 miles per hour, $230, and 40 or more over $425.
That's the House bill. And I would like to conform my bill to the House bill. Yeah, okay, good. So move favorable. It is amended.
I may have misspoke that the fines here in this bill are consistent with the fines in the cross-file of Senator Waldstreicher's bill that we talked about earlier. Not the SHA-related bills. I wasn't talking about those.
All right. It's a little confusing, but as currently filed, both House Bill 349 is consistent with the graduated fine, the statewide graduated fine. They both create a tiered system and increase all the fees, including the bottom level. Earlier, with regard to the earlier bill, I offered that perhaps we should, at the entry level, 12 miles per hour to 15 miles per hour above the speed limit, keep the fine at $40 in order to send a signal to our constituents that we're not doing this in order to catch people who are just going a little bit over the speed limit or otherwise to raise revenue. And so I've been informed that this bill has plenty of time to go back to the House for the House to agree to that, and then that would likely be the outcome. And I've spoken with the sponsor of the Senate bill, who has agreed to that as well. And so,
right, and the other, for the higher speed violations, the fines remain as the House passes. That's fair.
so So I think we can do this orally, if that's okay with council. So my amendment would simply be that for the lowest level tier, that we retain the $40 fee, amending it down from $50. $40 is the current fee under current law. All the other fines would remain the same as the House passed them.
So just for reference, on page 2 of House Bill 349, it's striking $50 and substituting $40. Sorry, line 18, that is.
You move the amendment. Is everyone okay? Is there a second? Everyone's okay with the amendment? All right, now the bill's before you as amended. The motion is for favorable.
No favorable.
Is there a second? All right. Is everyone okay being recorded in the affirmative? We need to roll. I know. All right. So Senator Fulton's down.
Okay.
Okay. Senator McKay. Okay. All right. Yeah.
10 to 1.
All right. House Bill 349 with the amendment passes 10-1. We'll now move on to Senate Bill 485, which is the cross-file. Motion is to conform it to what we just did, dropping it to 40. Everyone's okay conforming it? Is there a second? All right, now the bill is before you as amended. The motion's for a favorable. Does everyone like to be recorded in the same posture as you voted on for Senate Bill, for House Bill 349? All right, great. Senate Bill 485 with the amendment passes 10-1. All right, Josh. We'll now move on to House Bill 1171.
House Bill 1171 is the cross-file to Senate Bill 992, which is currently in the committee's possession. The bill establishes a process for the transfer of assets that are collateral for securing a mortgage, pledge, or security interest without stockholder approval, establishes exceptions to the process for the transfer of assets that are secured collateral without stockholder approval, and repeals certain statutory provisions that specify what must be included in the articles of merger of certain business entities. This is the bill that's annually brought by the business law section of the bar to make miscellaneous changes to the Corporations Associations article. So there is an amendment in your packet which simply conforms the bill to what was passed by the House, which just makes some technical and sort of stylistic changes to one of the provisions in the bill.
All right, the amendment's been.
So the House bill would be favorable, the Senate bill would be favorable.
Yeah. So favorable. All right, so motion for a favorable, has it been seconded? Second, is everyone okay being recorded in the affirmative? All right. This is. Okay. All right. Yep. All right. Everyone is, so House Bill 1171 passes unanimously. So now we'll go on to the cross-file Senate Bill 992. You want to adopt the amendment, or is the motion to conform?
Motion to conform.
Motion to conform. All right. It's been seconded. Is everyone okay being recorded in the affirmative as amended? Okay. Senate Bill 992 passes unanimously with the amendments. All right, we're now going to go on to, this is 1283. Are you ready for that, Josh? Yeah. All right. Senate Bill, wait, is that the?
House Bill 1283 is the cross-file to Senate Bill 912, which is in the committee's possession. The bill authorizes Charles County to regulate the operation of off-highway recreational vehicles, require the owners of such vehicles to register them with the county and pay a registration fee, to impose age restrictions on the operation of those vehicles, and to authorize impoundment of those vehicles if they are the subject of certain alleged violations of the criminal law or transportation article. The House passed the bill without amendments.
Senator Folden, there's been a motion for Senator Folden has the mic. Sure.
So this is off-highway recreational vehicles that they want them registered and they want a fee. It doesn't talk about how much the fee would be. If we're going to legislate something, I'd like to know exactly what we're legislating. So it doesn't give mention of what the fee would be. And then it says it imposing an age restriction on the operation of off-highway, so they're not on highway. So what is the age restriction that they're going to implement? So I think that this is a slippery slope when we start looking at adopting or giving carte blanche authority to the county. Like, I don't know why, is there a reason they can't just do this on their own already? Because this bill gives zero specific language on the registration fee, the age restriction, it says the impoundment, and then authorizing the impoundment of an off-highway recreational vehicle. I mean, if it's on the roadway, they can already impound it. So I'm really unclear on what this bill is trying to do, that we're given that type of latitude without specific language to the costs, fees, and the age restriction.
Well, just on the question of, why it might be necessary, I mean, the vehicle laws would preempt the local jurisdictions from doing things like registration requirements. The impoundment.
But why? It's not an on-roadway use vehicle. So why couldn't they require it if it's purchased in the county of origin by ordinance?
I believe, well, I'd have to get back to you on the specifics, but my understanding is they are not able to do this currently. I would have to get into the details of exactly why.
I'm sorry? I don't know. Charles.
Code Home Rule County, or is it just a Commissioners County?
It's commissioners.
Yeah, that's why it has to come here, because they don't have the ability to do that.
Okay, yeah, that's right.
That's what they're trying to do.
Put some specificity.
Home Rule County, and we're participating with creating a Hatfield-McCoy trail that will go from Florida all the way to New York. And because we are already a Code Home Rule County, there's talk of a registration and those type of things.
Allegheny and Garrett.
You see, I mean, check out, I mean, look,
But it's
this isn't my bill. I mean, like, just the Charles County Sheriff's Office has testimony that I thought was pretty compelling. Take a look at that in the file, and then see if you still have the same concerns. We do have a delegation letter.
Looks like you have one. Yeah, I mean, this is exactly what I thought it was. It's about ATVs and dirt bikes riding on the roadways. It's the same issue that Baltimore City has and that these other jurisdictions are having, that they're not able to, I don't know why they think they can't. One, they're not going to chase them. Two, if they're driving on the roadway, it's already illegal. They can tow it, but the people aren't stopping because they're riding off-road. So I guess what they're saying is they want to be able to register them so that they can attempt to at least identify them in some manner of what it would look like.
Correct.
Which would make sense. However, well, that's a policy decision at the sheriff's office. They have the authority to impound it. If it's on a roadway that's not legally registered, I don't know why they can't tow the vehicle.
Well, if you look at the bill, they are attempting to gain the ability to impound them for trespassing, so I assume some of the situations they're talking about are people are on just private property with these things, and that is presumably what they're looking to do with sections, 6404 and 6405 of the criminal article.
Okay.
Those are trespassing offenses.
I'm not trying to hold the bill up. I just point out that
Move the bill.
It's been a motion for favorable. It's been seconded. Do we need a roll call? All right, let's do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
pass.
Senator James.
Yes.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Senator Folden.
I will do it as a, I know, it's a local bill. Thank you, my whisperers. I've voted against a local bill before, but I won't on this one. I'm good.
Chairman Smith.
Yes. Unanimously. We're now going to go on to the Senate bill. Senate Bill 912. All right, straight up favorable. Is everyone okay being recorded? Prior vote, all right. Senate Bill 912 passes unanimously. We're going to go to House Bill 1465.
So as amended by the House, House Bill 1465 requires the Maryland Transportation Authority to establish an installment payment plan program for the payment of certain video tolls and civil penalties. Person would be eligible to apply to participate if they accumulate at least $300 in unpaid tolls or penalties. So my understanding is that the amended House bill reflects a program that the Transportation Authority is already developing and is in the process of rolling out. So as you can see in the fiscal note, it eliminated the fiscal impact of the bill by eliminating some of the income requirements, as well as by removing from the bill a provision that applied to the Department of Transportation.
All right, there's been a motion for favorable. It's been seconded. Senator Waldstreicher.
This is a good bill, and I'm going to support it, and proudly so. I just want to put something on the record because this, I think, opens the door to something that I do not support, and I don't know if the sponsor supports it, but other jurisdictions are moving to income-based ticketing. The District of Columbia is considering giving different tickets to people depending on their income. San Francisco has already done this. What's that? How could they figure out I think it's self-attestation. I imagine a lot of people are attesting to a lower income. Yes. Anyway, so this bill does not do that, but it opens the idea that we might head in that direction. I just kind of want to mark this moment that I think that would be that other jurisdictions have struggled not just with the ideology behind it, but the implementation of it. And I think that would be concerning if we were to do that in Maryland. So just want to express that and express my support for the bill.
So it's been seconded. Is everyone okay being recorded in the affirmative? You're seconding the comments or seconding the bill? All right. Well, do you still want to be up on the bill?
I'll second the bill.
Okay, all right. All right, so House Bill 1465 passes unanimously. Now bring up the Senate Bill 941. The motion is to conform. Second, is everyone okay being recorded in the affirmative? All right, Senate Bill 941 passes with the amendment unanimously. Voting list 18. All right.
Stuff here, but we have a pretty lengthy bill hearings today. Is there any consideration to coming back to voting
The
on
House is
list
still on
18?
the floor. We don't have any delegates. We're still going.
Well, then I just we can do a consent calendar, unfavorable. No?
First time I've been looking at something like this.
Dang.
But I'm with you.
I was trying,
I'm
buddy.
with you. Which calendar is 238? Yeah, I'm gonna hold that. Yep. Looking at something.
All right, we're now on to House Bill 1.
House Bill 1 is the cross-file to Senate Bill 7, which passed the Senate without amendments. The bill generally requires the Department of Transportation, in consultation with stakeholders, to develop or identify and implement a training program that includes a curriculum on the identification and reporting of suspected human trafficking. So the House did have a couple of amendments. So if you look at the copy of the bill on page 2, see there on line 24 and 25, it clarifies that the training may be provided to the extent feasible during regular working hours. And on page 3, line 5, it pushed back the date by which the department or the employers are required to certify to the department that their employees have completed the training program from January 1, 2026 to January 1, 2027. The impact of those amendments, they had a minor impact on the fiscal impact. The Senate bill, as passed, had a fiscal impact of about $455,000 in the first year. As you can see from the fiscal note, The House amendments reduced that down a little bit to about 400,000 spread out over 2 years. So you could either pass the House version or conform it back to the Senate version.
I don't remember the fiscal impact. Did we deal with that when we passed it in the Senate? Yeah. And then we passed it. Okay, so it's in this year's budget, proposed budget.
I don't know about that, but I believe Budget and Tax gave their blessing to the bill as it was drafted.
Okay.
To conform it to the Senate. Since we have received approval from B&T, then let's just conform it to the Senate version. So the motion is conform House Bill 1. What is the cross file?
Second. Hold on, the cross file number is Senate Bill 7.
To Senate Bill 7. Okay, it's been seconded. Is everyone okay? All right, now the bill's before you as amended. Motions for favorable. Second, everyone okay being recorded in the affirmative? Great. House Bill 1 passes with the amendments. Now move on to House Bill 4.
House Bill 4 is the cross-file to Senate Bill 120, which the Senate passed without amendments. It alters the statutory provisions that prohibit unreasonable restrictions on land use related to solar collection system installations. It's in the same posture as the Senate bill was passed.
Motions for favorable. It's been seconded. Is everyone okay being, hold?
So
All right.
Holden
Hold on.
and McKay voted against it before. You want to vote it down again? Both Holden and McKay?
Yeah.
I just noted I voted against. On the floor of the Senate bill, so to be consistent, I need to vote against the House bill.
This is House Bill 4.
And then against on the floor? Well, that sounds consistent.
So if you're gonna be consistent, vote for it.
This was Senate Bill 120? I
I only have your, the JPR vote, I can pull up the other vote.
Yeah.
And to be consistent, he should vote yes on this one.
Yeah, to be consistent, he should vote yes in committee. No.
Right. So I have to vote no on this.
I do too. I think I screwed, I remember you voted last year and.
And Holden are down.
All right. We'll now move on to House Bill 39.
House Bill 39 is the cross-file to Senate Bill 356. The bills are identical, but the vote was not unanimous. The bills repeal the misdemeanor prohibition against and associated penalty for knowingly transferring or attempting to transfer HIV to another.
Motions for favorable.
Second. And then.
And let's keep the same
Senator
vote as.
Holden was down. And, yeah, okay.
All right.
Everybody else good?
All right, we'll now move on. So House Bill 39 passes 10-1. We'll now move on to House Bill 123.
House Bill 123 is the cross-file to Senate Bill 197, which was passed with amendments by the Senate. It's a departmental bill that expands membership of the Correctional Training Commission to include the Director of the Division of Parole and Probation, as well as one parole and probation employee as recommended by the exclusive representative for those employees and appointed by the governor. There is a difference between the bills, which is that in the Senate bill, there was some additional language which makes it clear that the parole and probation employee may not designate someone to serve in their stead. So as the House passed it, technically that employee could essentially have a designee serve instead of them. With the Senate version, that's corrected.
Motions to conform to the Senate bill. It's been seconded. Is everyone okay? All right. Now House Bill 123 is before you as amended. Motions for is favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 123 passes with the amendment unanimously. Now move on to House Bill 124.
House Bill 124 is the cross-file to Senate Bill 160 that was passed by the Senate. It requires a wholesale buyer or wholesale seller to provide certain disclosures in the contract for sale of residential property and authorizes the rescission of a contract and requires certain funds under certain circumstances related to the required disclosures. It is the same posture as Senate Bill 160. There is just a technical difference in the purpose paragraph, but the House side is going to take care of that. This would be favorable.
All right, motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, there's been a request to hold House Bill 238. We're going to go on to now House Bill 259.
House Bill 259 is a departmental bill from the Department of State Police. It alters the circumstances in which a DNA sample must be collected and stored in the statewide DNA database system within DSP's crime laboratory, alters the individuals required to collect DNA samples and the process for collection, and clarifies when a DNA sample may be tested, placed in the statewide DNA database system, or destroyed and expunged. The bill also requires the releasing entity before releasing an individual from custody to ensure that the individual's required DNA sample has been collected as required by the public safety article. In addition, the bill prohibits an individual from refusing to provide a DNA sample as required, and it discharges an employee from the duty to collect a DNA sample when an individual refuses to submit the sample, and establishes penalties for violations. This bill is the cross-file to Senate Bill 202. Just to refresh the committee on it, the committee had amended Senate Bill 202 to exclude situations where probable cause determinations had been made by district court commissioners based on a statement of charges filed by a member of the public. The House adopted slightly different language to what the Judicial Proceedings Committee adopted, and actually sort of accounted for some cumbersome wording. So just to, I'll just read what the House had done with respect to that portion. It provides a DNA sample collected from an individual charged with a crime under subsection A3 of the section may only be tested or placed in the statewide DNA database system if, one, a determination is made by a judge or commissioner of the district court or a judge of the circuit court based on an application for a statement of charges filed by a police officer or state's attorney that probable cause exists for a qualifying crime in accordance with the Maryland rules. Two, the individual has been arrested for a qualifying crime in accordance with an arrest warrant based on an application for a statement of charges filed by a police officer or a state's attorney. Three, an information is filed by a state's attorney for a qualifying crime. Or four, an indictment is returned by a grand jury charging the individual with a qualifying crime. So that language actually removed some double negatives that appeared in the existing law. And otherwise, the Judicial Proceedings Committee in the Senate version had lowered the penalty from $10,000 to $1,000. The House actually went with that change as well.
So I have a quick question for council. Does the House wording?
It's cleaner.
Yeah, okay. Does the House wording effectuate the policy that the Senate wanted to do through its amendments? And in its drafting, without regard to that policy, is the drafting cleaner or more elegant than what the Senate did?
Yes, Senator, it's my view that it does.
All right, so the motion, just straight favorable, right? Motion's for favorable? It's been seconded? Is everyone okay being recorded in the affirmative? All right, House Bill 259 passes unanimously. Say what? I know. All right, let's go ahead and go to House Bill 292.
House Bill 292 is the cross-file to Senate Bill 63 that was passed by the Senate. It makes various changes related to the requirements for common ownership communities to fund reserve accounts, including about prepare for a specified funding plan, extending the amount of time after initial reserve study to attain the recommended funding level, and authorizes these communities to declare financial hardship and deviate from that plan. There's one difference between this and the Senate version that was passed. In the Senate version, there was a provision that included in the bill that would allow them to borrow from these funding plans and then would have to repay it within 5 years. It's my understanding the House is going to go with the Senate version, so to conform, it would just add that provision into the House bill.
All right, the motion then is to conform to the Senate bill. All right, is everyone okay with that? With the amendment, yep. All right, so I've been asked to continue along with the voting session. So House Bill 292 is now before us as amended to conform to the Senate version. Is everyone good with that? Yeah. Okay.
Senator Folden, you were also down. And Senator McKay? You're up, okay.
All right, so our votes are now consistent with the Senate bill. House Bill 292 passes as amended to conform to the Senate bill. We'll now move on to House Bill 343. Josh.
House Bill 343 is identical to the Senate cross-file, Senate Bill 390, which passed the Senate, but it was not unanimous. The bill authorizes a technician employed by or under contract with an agency, rather than only a duly authorized law enforcement officer, to sign a statement and a citation alleging that a speed monitoring system violation has occurred, and to swear or affirm that a speed monitoring system violation occurred after inspection of the recorded image. The bill also requires a duly authorized law enforcement officer or technician employed by or under contract with the agency to complete reasonable training specific to the speed monitoring system before certifying any certificates of violations.
All right, so the motion is for a favorable. This is in the same posture as the Senate bill. All right.
So Senator West, you abstained on the Senate bill?
I had it on the floor. I think I voted yes, didn't I?
Yes, you did vote yes on the floor, so you good? Okay, Senator Folden, you were down.
I'm down.
And Senator McKay is down.
All right, so House Bill 343 passes with votes consistent with the Senate cross-file. We'll now move back up one to House Bill 315. I'm sorry.
That was when I had the flu.
Senator
So
James.
for right now, since I'm not familiar, I'm just going to vote no and see, may change after it gets on the floor. Thank you.
Seven to three. Or
8-3.
8-3.
Let's go back to 315.
All right, so we're gonna go back to House Bill 315.
House Bill 315 is the cross-file to Senate Bill 22. It establishes a task force to study fiduciary adjudication in Maryland. The governor has to designate the chair. The administrative office of the courts must provide staff for the task force, and the task force must report its findings and recommendations to the governor and General Assembly by January 1st, 2026. There is a difference between the two versions as introduced. Just simply on page 3 and line 11, it would change one of the tasks to be about analyzing not fiduciary. Where is it?